All right, I think that we've got everybody, looks like everybody here now. Well, welcome everyone to our 2023 in-house law update through the IP section of the State Bar. We're very excited to have everybody on board today. I think we have a pretty entertaining program for everybody. Just to get started, I'm one of the co-chairs of the in-house committee here at the State Bar. I spent years working in-house at local Kids Too. I'm currently a partner at a law firm called Perla Knox and Hildebrandt, largely focused on IP litigation, and work with some of the folks here on the panel today. Also, my co-chair is Justin Ward. He is a corporate attorney with Blue Force Gear, recently left Daniel Defense. Experience in all types of intellectual property law. I think he's handled a little bit of everything in his career: IP litigation, prosecution, transactional work, and we're excited that he is on the panel as well today. We also have Robert Guaba. He is in-house at ADT in Florida. Robert and I used to work together at Thomas Horstmeyer a few years ago, before he left to join ADT. He's currently focused on IP litigation and patent drafting and prosecution for ADT. And he's got a substantial amount of knowledge on a couple of key topics that we're going to have Rob talk about today as we walk through this. Justin, you want to introduce Michael?
Yes. Thank you for the introduction and welcome everyone. We have Mike Secor, Senior Lead IP Counsel at Dexcom. Mike has extensive experience in both product and intellectual property. He has a computer engineering degree, as well as a technical background. He's worked mostly for technology companies, but also recently started a medical device company. He's admitted in California, Illinois, and before the USPTO. I met Mike at a California CLE event, so we greatly appreciate that he's here and participating. He's got lots of insight. So to cover the topics today, we are going to be covering third-party litigation funding and venue trends, quick NPE tips, generative AI, general thoughts, interest level, experience, and concerns. And if we have time, patent inventorship. Please feel free, if you have any questions during any topic, to raise your hand. We will pause at the end of each topic and have questions. We will also, at the end of the presentation, leave 10 to 15 minutes for audience questions. So thank you, and let's get started with the third-party litigation funding and venue trends.
Yeah, absolutely. So as we get kind of walk into this topic, Rob, I think, is our resident specialist here on this topic. And as we plan for this CLE, we've done had a lot of group conference calls and to discuss these topics. And I think that we've all actually, in planning this CLE, have learned a good bit from Rob, and we're excited to share a little bit about why this matters. So, Rob, why don't you tell us a little bit about what is third-party litigation funding? I think people maybe have a basic idea about it, but give us a little more information on that. And then, really, why should we care? Why should in-house folks care?
Yeah, thanks, Joe, for the introduction. So third-party litigation funding, the U.S. Government Accountability Office has actually given us a definition on the next slide here of what third-party litigation funding is. But the diagram on the below is probably better illustrates the concept. So starting on the left here, you have a group of investors who pool their capital together and put it into a litigation funding vehicle. That vehicle then provides funding to typically a plaintiff for the purposes of fees and expenses in a litigation. If there's a recovery in the litigation, then a portion of those proceeds go back to the investors. If there is no recovery, then the investors go home with a big goose egg. So why do we care? So there's a couple main reasons. First of all, there's a concern that if a party is using third-party litigation funding, that the funders can exercise undue control over the litigation possibly bring some cases that are lacking in merit. Also, if there's some third-party litigation funding, there's a concern that the party is going to be less likely to settle because they're seeking a return on investment rather than a just actually just trying to resolve the merits of the litigation.
Rob, is this typical? I mean, obviously it says typically a plaintiff. Are there any instances that you're aware of in which litigation funding has been used in a defense context? Is that something that maybe tech startups are doing? Have you seen anything like that?
I personally have not seen anything like that. The reports I've read said that it's typically the plaintiff who receives the funding. So I guess theoretically it's possible. I would imagine that third-party litigation funders are probably a little more hesitant to fund a defendant who would bring a counterclaim. But again, I think it's possible.
Is there anything else on this slide that we need to cover?
No, let's go to the next one.
All right.
All right, so this slide shows the current state of third-party litigation funding. This is actually based off of 2022 data. And referring to the left side of this slide. So in general, there's two types of third-party litigation funding arrangements that exist. The first is single case arrangements where a third-party funder will fund only a single litigation. You can see in that pie chart about a third of the third-party litigation funding cases are single case arrangements. And the average investment amount is about $4.3 million. The other type of arrangement is a portfolio-based arrangement where the funder will fund a group of cases for a party or even a group of cases for a law firm. You can see on the left side that about 2/3 of third-party litigation fundings are portfolio-based. And the average investment amount for those types of cases is about $10 million. And then on the right side, that is some data that is patent specific. And you can see there that of all third-party litigation funding cases, about 20% is patent litigation, 79% is non-patent litigation. Typically that is large damage cases like class actions or antitrust. Or maybe large corporate issues. What's most interesting about the data here is that graph on the bottom, the timeline. So back in 2010, third-party litigation funding for patent litigations was pretty much unheard of. But as of 2022, about a third of all patent litigations involve some sort of third-party litigation funding.
So it looks like it's pretty steady at 30% from 2020 on. What do you see as the future? Do you see any trends going up or down?
So that's a good question. So part of the challenge here is that there's not data that's easily accessible. The data from this entire presentation is typically from surveys where either government or some trade organizations will survey third-party litigation funders. So it's not clear if this data is complete or inaccurate in any way. I would suspect that it's probably going to cap out at some point. I'm not sure if that 30% number is where it's at, and if that flattening in the curve in 2020 was due to COVID or for something else.
And what do you typically see for a third-party funder? What's an ROI? What's a return on investment that one can expect if they want to participate in this?
Well, so that's another area where the data is pretty unclear, and a lot of it is self-reported. For example, IPEdge, which is a well-known patent investment entity, they self-report that they have returned 3x of what they've invested on patent monetization. Really, it's kind of up to the particular agreement on what a third-party litigation funder is going to receive if the case is successful. It can be multiplier based, where the returns will be in the form of a multiplier of what was invested, or it can be percentage based. I've seen a report where it said that third-party litigation funders are seeking 10x return, but that seems very high to me. That 3x return seems more reasonable, but again, the data is pretty unclear. It's hard to tell.
Thank you.
Yeah, I know. So one thing that every case that we handle, or when I was in-house, even we would get hit with emails. We get flooded with emails at the initiation of every case from third-party litigation funding sources trying to have a communication or discuss possible funding. Is this something that, Rob, you're seeing that is, how are, let me put it this way, how are people connecting with these third-party litigation funding sources? Are the in-house folks going out, reaching out and looking for these, or at the initiation of a case, or in your experience or understanding, how does that work?
Yeah, I think it's probably a mixture of both. I think as third-party litigation is becoming more and more popular and companies are aware that it exists, that's probably something that is explored before the suit is actually filed. I personally have not seen a case where after the suit was filed, third-party litigation funders approach the plaintiff or defendant, but I'm sure that's possible too.
Yeah, we get a lot of that. So if we file a case, we're getting it post initiation of suit, and so that's why I was wondering if that's is that the norm in your experience? Sounds like it's not. It sounds like a lot of these plaintiffs are looking for these situations before the cases are filed. Yeah,
I suspect that's the case now that there's some momentum in the amount of cases and it's becoming more popular.
Right. Yeah. I think as we'll go through the slides, in terms of whether the number is holding steady at 30%, I think that we're going to talk about some of the disclosure requirements, right? But yeah, so we really don't know what the number is. Like you said, this is all self-reported survey information, correct?
Yep, exactly.
And Joe, one thing that I can add, I've been pitched a lot lately on we have a lot of counterfeit problems. So there's been lots of third-party funders reached out to us to try to fund international lawsuits, and in my opinion, that's a great idea, because I'm not too familiar with each individual country. We have lots of counterfeits in China, so that would be ideal. The only thing there is you really have to have your intellectual property filed in those countries. So that's one of the things I'm working on now is where we have these counterfeiters, we have to make sure that we have the proper trademarks, as well as patents as well, in case we do want to file suit in these countries.
So are they actually bringing you, they're out there kind of policing the market for you, or are you identifying the problems ahead of time, or are they identifying these problems for you?
It's more that, we communicate that, hey, we have these counterfeiting issues, and hey, here's a solution. We have software to automate to take down these listings in these various marketplaces. And also, if you want to go after the source, instead of going after like the resellers, we can go to those countries and kind of, get the source of the goods, which would help in the downstream market. Got it.
All right. Great questions. Rob, you ready for the next slide?
Yeah, let's go to the next one. Yeah, so a recent hot topic in patent law is disclosure of third-party litigation funding in patent cases. And this slide just shows that generally most federal courts do not require disclosure of third-party litigation funding. Obviously, there's Rule 7.1, which requires disclosure of the parent corporations and publicly held corporations that hold 10% or more stock. There's also Rule 26 that requires production of insurance agreements. I mean, there's some districts that actually have some local rules that require the parties to provide disclosure of non-parties having financial interests. But most courts in general do not have an explicit rule that requires disclosure of third-party litigation funders. And next slide, please. But there are a couple of courts that do require such disclosure. For example, the District of New Jersey has a local rule that requires the disclosure of any third-party funders to specify the financial interest in the litigation and whether their approval is necessary on litigation decisions or settlement decisions. It also specifies the instances when discovery in terms of a third-party litigation funding arrangement is discoverable. Also Judge Connolly, he's a chief judge of the District of Delaware. He issued a standing order in April of 2022 that appears to be modeled off of the New Jersey local rule. Requires the same sort of information, the identity of the third-party funders, their financial interests, and whether they are necessary for litigation or settlement decisions. And Judge Connolly's standing order has resulted in a couple of interesting cases, which are discussed on the following slide.
Okay.
So the first one that made headlines for a while is In re Nimitz Technologies. It actually ended up at the Federal Circuit. The background of this case is Judge Connolly had ordered the plaintiff, Nimitz, to certify compliance with his standing order regarding disclosure of third-party litigation funding. The attorneys for Nimitz initially missed the deadline to file that certification, but they eventually filed one. And in that certification, they represented that it had not entered into a third-party litigation funding agreement, quote, as defined in the court's standing order. However, Judge Connolly later became aware from exhibits in another case that Nimitz may be connected to IPEdge, which was not identified in the disclosure statement and which is known to be connected with third-party litigation funding. So in light of that discovery, Judge Connolly ordered the production of documents relating to the formation and operation of Nimitz. And those documents that he saw were attorney communications, bank statements, some very invasive information. So Nimitz opposed the order and petitioned the Federal Circuit for a writ of mandamus to reverse that order. After Nimitz had petitioned the Federal Circuit for that writ, Judge Connolly actually issued a memorandum explaining why he was seeking those records. And he explained that he was seeking them because they were relevant to issues concerning whether real parties and interests had been hidden from the court. The Federal Circuit issued a decision denying the petition because on the basis that it found that Nimitz had not shown that it had a clear and indisputable right to relief. So Nimitz appealed to the Supreme Court, but recently, within the last few days, Nimitz filed a notice of stipulated dismissal from that case. And I haven't seen any formal dismissal from the court, so it's unclear whether the appeal to the Supreme Court is moot or not at this point. And next slide, please. The other interesting case that has arisen out of Judge Connolly's standing order is VLSI v. Intel. VLSI and Intel have several litigations where VLSI is suing Intel. In this particular case, VLSI sued Intel in 2018, originally seeking $4 billion in damages. So that was in 2018 when they filed the case. In July 2022, Judge Connolly ordered both parties to certify that they have complied with the standing order on litigation funding. So VLSI, in response to that order, they filed a declaration from their CEO and they filed it under seal. The court then unsealed the declaration and also found that it failed to comply with Judge Connolly's Rule 7.1 disclosure order, and that it also raised questions about whether VLSI had complied with the litigation funding order. So in light of that finding, Judge Connolly stayed the litigation. There was months of briefing on the issue, and then about 4 or 5 months after the case was stayed, the parties filed a stipulation dismissing VLSI's claims with prejudice and Intel's claims without prejudice. What's most interesting is the stipulation also states that neither party is paying any amount to the other party. So VLSI filed this case seeking $4 billion in damages. Once the third-party litigation disclosure issue came up, VLSI dropped the case and walked away without getting a penny. So that was pretty interesting.
Robert, is there any indication from your reading on this as to why, once the Rule 7.1 disclosure issue came about, that the case ended up being dismissed? Is there, or do you have any guess as to what was behind that?
I don't have any. So based on what I can read, it appears that the dismissal is a result of Judge Connolly wanting the VLSI to disclose the funders in the case.
Right.
Yeah. So I don't know anything beyond that.
And that's substantial enough to get a $4 billion case dismissed, huh?
That's what it sounds like. Yeah.
Wow. All right. Next slide.
Yeah, next slide, please. Yeah, so the next couple of slides are some graphics illustrating the effect of Judge Connolly's third-party litigation funding order. So that chart on the left, that shows, I've circled in red, when Judge Connolly issued that order of requiring parties to disclose third-party litigation funders. And you can see, as soon as he issued that order, the number of patent litigations that were filed in the District of Delaware dropped significantly. So in April of 2022, there were approximately 60 cases filed. I'm sorry, 78 cases filed. And then in December of that year, there were, I think, 22 cases. So substantial drop. And if you look at the graph, so purple is the Western District of Texas, and that green color is the Eastern District of Texas. So it looks like parties, to the extent they're able to, have decided, instead of filing suit in Delaware, they've moved those cases to file them in either Eastern District or the Western District of Texas. The chart on the right illustrates, what do they call them? Litigation investment in entities is what Unified Patents refers to them as, but it shows that there's been a 83% drop in filings in those cases, and that coincides with the date that Judge Connolly he issued that standing order. And if you go to the next slide, you can see that actually the number of patent filings in general has decreased since that third-party litigation funding order was issued by about 32% year over year. So it does appear to have had a significant impact in the number of cases filed. And the final slide I have on this topic relates to some new legislation that's been proposed. There are two bills, one from the Senate side and one from the House. They mirror each other. They're supported by, there's bipartisan support, bipartisan sponsors, and it addresses the issue of third-party litigation funding by foreign governments and foreign wealth funds. This bill has been given a 3% chance of actually being enacted by the website GovTrack. But if it is enacted, it would require the disclosure of any non-party that is a foreign person or entity that has a right to receive any payment that's contingent on the outcome of the litigation. It would require the automatic production of any third-party litigation funding agreements to the opposing parties and to the court. And they will also ban sovereign wealth funds and foreign governments from participating in third-party litigation funding.
All right. So I think we were, to kind of put a bow on this topic, one thing that we were talking about when we were planning this is that one of the big concerns that appears is that either foreign entities, corporations, or governments are investing heavily in the patent system, so to speak, by investing in these cases and targeting specific American corporations, right? Is that so? I think Robert and Michael, we were talking about this a little bit beforehand, but is that ultimately what the concern here is? Is that what what these bills are trying to target?
Yeah, I think the concern here is that foreign governments can use the U.S. Patent system to undermine innovative companies that are based in the United States, and not only profit off of that, but also hurt U.S. innovation. So I think that's what this bill is intended to impact.
I'm kind of surprised it's only got a 3% chance of being enacted. It looks to me like something that we ought to be taking a serious look at. So, but anyway, all right. So, was there anything else here that we needed to cover?
Do we want to open up any questions from the audience? Does anyone have any questions? I think you can just unmute and then ask the question or raise your hand. So please let us know if you have any questions on this first topic.
All right.
No questions. So the next topic is NPE litigations. It's a huge topic for in-house counsel. Mike happens to be an expert on the topic. So he wanted to throw in here some quick tips. So Mike, why don't you tell us a little bit about your slide?
Sure. Well, thank you very much for the introduction. So basically, I'd like to start out with sort of my philosophy. If you can go to the next slide. And my perspective on things. Basically, it's from a sort of Silicon Valley tech company perspective, which is where a bunch of my experience comes from. So my philosophy is to treat NPEs a lot like bullies. So feeding them or giving them what they want only encourages them to come back. Think of sort of the bully wanting somebody's lunch money, where basically if they get your lunch money the first day, they're coming back the next day. And so basically, nuisance settlements can be used in specific cases, but you don't want to become known as someone who writes checks very easily. So one of the ways that I find to deal with NPEs is to basically make yourself very unpalatable or difficult for them to deal with. So that usually starts out with, which the normal standard is to send them a Rule 11 letter early on in the case to show the NPE that you mean business. Now, one of the things that I think is sort of unique and I've had success with, and I encourage others to try to do, is to basically get a declaration put together. And this sort of builds on top of the Rule 11 letter. And what you do is you get a declaration from a founder, a co-founder, some technical people, inventors within the company, et cetera, to put pressure on the NPE. Because basically this declaration, you point out that their infringement case is weak. And so this being done early on in the case increases the potential of risk for sanctions, because you're effectively putting the NPE on notice that their case is weak. So I've got here sort of the, I guess you could say, a recipe. You've got your example components. So basically give a background, education, experience, the role of the person writing signing the declaration, a statement that they've reviewed the complaint, statement that the company does not practice the allegedly infringed technology or invention. And I've had this work successfully because usually the NPEs don't want to deal with the raised risk, as well as the fact that they've been put on notice early on. So I find this to be a pretty effective thing and encourage people to do it if it's appropriate and relevant for the situation. Another thing I've seen used effectively is if you got a patent involved in an NPE case where it's something that's related to a standard or something like a standard, where it's commonly adopted by a certain industry, I would recommend requesting copies of the license as soon as you can, if it's relevant. So for example, I know of a case where basically there was a standard that was related to an operating system software, and a very large operating system software company basically had a license or got a license from the troll or a troll along the line. And with that, basically that applied to anybody else who was interacting with the operating system. So because of that, when the NPE came after people with the standard, at least in a couple cases, the targets of the NPE's lawsuit was able to try to get a copy of the license, which of course the NPE did not want to give. And so basically the NPE sort of walked away without anything. And so overall, I think another aspect is to think about the fact that, or think about it from the perspective that NPEs are businesses. So they have time and money constraints. So the more difficult you can make things for them, the more of their time and their money that they're going to use. And of course, in light of or in connection to the previous topic, the third-party funders want their money as soon as possible. So you can effectively make things less appealing as the target of an NPE suit if you're more difficult. So you can think of challenging stuff on 101, for example.
Yeah, I think that's very helpful. Make yourself as difficult as possible. Raise the amount of time and money that they have to spend. If they get fed up, then they can just go pick on someone else. So I think that's great. Great tips. Very helpful for the in-house as well as the law firms as well. If there are no questions, we can move on to the next topic. All right, generative AI, general thoughts, interest, level, experience, and concerns. Mike, I know this topic is near and dear to your heart. What are some AI tools that people are currently using and that's available?
Well, first I'll start out with a quick definition of generative AI just to make sure everybody's on the same page. And basically it's technology that can create new content in response to prompts, which can include text, speech, and images. And in fact, this morning I just saw on the news that Biden signed an executive order related to AI. So it's becoming a very, very popular thing. As far as AI tools go, many of us have heard of ChatGPT, which is a very popular text-based generative AI tool. And it actually holds the record for the fastest user growth in internet history, reaching 100 million users in 2 months. So that's faster than TikTok, Instagram, Pinterest, Spotify, Uber. Other popular AI tools include Google's AI tools. So they've got Bard, which is similar to ChatGPT, but it's for consumers. And then their business product is called Duet for AI stuff. And then basically, as you might expect, Microsoft and Google, which Microsoft has a very close relationship with OpenAI, which is the company behind ChatGPT. Both Microsoft and Google are integrating AI into their office and workspace platforms. Other popular AI platforms or tools, you've got GitHub's Copilot, which uses AI to help with coding and code review. And then Midjourney, which is a system that creates images from natural language descriptions. And then even Adobe has started integrating AI image technology into Photoshop and their other platforms.
All right, Joe, let's move to the next slide. All right, Mike, can you talk through this slide a little bit?
Sure. So basically, you want to be very careful about information that's put into an AI tool, as it may no longer be considered confidential or trade secret. So this is one thing that's raising a lot of concerns. Now, of course, when I say this, I'm referring to AI tools that are publicly available. So for example, if you have your employees or the workers at a company entering stuff into ChatGPT, basically that stuff is may no longer be considered confidential or a trade secret. And it could become part of the output provided to other users. So the worst case scenario, of course, would be, think about if ChatGPT was providing your competitors confidential information directly or other trade secret information. Then you've got a risk of copyright infringement. So AI reuses information in some cases, as well as just uses information based on information it's got. So you could have copyrighted source code that was input by somebody, or say your company, that's now becoming output to competitors or other users. You could also have, depending on if you're dealing with API calls or developing API calls, you could possibly get into a whole situation similar to the Google versus Oracle Java API case that went on for many years. And then, of course, you've got a similar concern here to plagiarism. So sources that ChatGPT or other AI platforms are using are not readily accessible to end users. So basically, use caution to ensure that you are not exposing yourself or your company to liability or public relations issues.
I've got a question, but before we go on the first two things with the trade dress and the copyright infringement stuff. So if you're in-house, what do you recommend that the in-house corporate attorney should do to make sure that the employees who might not be familiar with the various nuances aren't entering in this information to try to get a document created to show to the rest of the company? Is there any policy, or what should we do?
Yeah, I do have a slide on this, but basically, generally speaking, you want to have a policy. You want to train and make sure everyone's trained in understanding these tools so that they don't enter things that, you don't want to become public, as well as, putting limits on things. Now, of course, there can be a whole variety of the way that you do this, education, policies, you have certification for training. You could, in theory, have limits put on your network so that, for example, you can't go to OpenAI or ChatGPT, for example, to actually, prevent people within the company from using it. To limit it, there's a variety of things you can do. You, of course, want to have policies associated with all this. That's sort of the way to, make everybody aware of it. And of course, your policies could define what you're doing with the various, put what limits you're putting on things, as well as what you want users to understand or certify that they've read.
Very helpful. Attorneys using AI and different software. What are your thoughts? What do most attorneys use? And then what are some potential issues with the results that they're finding?
Well, I'd say the biggest uses, or at least the most common uses for attorneys to use AI for generating contract language, or even entire documents, depending on what they're doing, summarizing documents or court cases, summarizing large PDFs, for example. E-discovery, you can do more sophisticated searching potentially of large document sets or data sets as part of e-discovery. Legal research, regulations, statutes, practice areas, stuff for special jurisdictions or other case law, but of course, be careful of hallucinations.
Yeah, tell us more what hallucinations are. I just learned about that topic recently, so.
Yeah, so hallucinations are basically defined as factual inaccuracies or references to non-existing sources. So AI in some contexts will provide an answer, but it can be based on little to no information. So I personally have observed, just in a personal context, that if you tell AI to look at a very sparse or limited data set, it will try to generate a response, but of course, if it doesn't have sufficient data, it's going to produce a response, but it may not be based on anything. One way to sort of think about this is that AI is actually sort of predicting the next word as it generates the responses. And because of that, if it's got limited data set that you're having it look at, or even limited data set out there on the internet, or it wasn't trained on a large portion of data related to whatever you're querying about, it will produce a response, and it appears to be confident, if you want to use confidence, quote unquote, in its response, but the accuracy may be very troublesome. Now, of course, there was a case that recently made the news where 2 New York lawyers who submitted a legal brief that included 6 fictitious case citations that was generated by ChatGPT were fined, and also was their firm.
Yeah, that's hilarious. I do remember that case. All right, Joe, you want to move to the next slide?
Actually, if we can, on the last slide, if I can just touch on one other point, because I think I didn't mention the IP and license infringement aspect, which I think can be very seriously. I have a bunch of experience in open source, and so open source can, of course, create a lot of headaches. So a concern about using AI, especially in the sort of a source code situation, is you can, of course, have open source or third-party code potentially provided to you, meaning your product could now infringe a patent, or from the very serious open source side, where you have licenses that require disclosure of source code, including like the Affero GPL, which requires disclosure of source code from the cloud. That could be really disastrous for a company. So you want to be very careful about making sure whatever tool that's being used is such that it's not including open source that is under licenses that you don't want. So we can move on to the next slide.
Right.
So I've got some examples here to sort of show the pitfalls, or at least the concerns that can be raised. So the first one is you might have an email chain or something that's very long, or maybe even a PDF. And so AI could potentially help you save a whole bunch of time in summarizing. But the danger is that you could have confidential or trade secret information in it, or even a strategy. Now, this being input into a AI platform could result in it basically becoming non-confidential anymore or public now. So the sort of nightmare scenario would be, consider that you have a special strategy you're working on and it could be provided directly to a competitor. So that would be very dangerous. One of the ways I think to think about this is think of the standard that's been mentioned for a long time for the internet, where you don't want to post anything that you wouldn't want to see on the cover of a newspaper. And this is sort of similar to the other saying that the internet is forever, meaning that you can't control things once they are on the internet. And the same very much likely applies to AI. AI models can be very challenging to debug. So changing them based on, for example, input of things that you don't want in there could be similarly challenging to get that data out of there.
And you, Mike, you got to figure that great minds, think alike. So your competitors are going to be asking the same questions that you're asking. I see it all the time with engineers and coming up with new products. So it's not a coincidence. If people are asking the same questions, it goes in the same database, then you're going to get competitor information. So I think that's a very valid point.
Yeah, that's a great point. I definitely agree with you on that. So then source code, which is sort of similar. AI tools can be very, very effective for optimizing code performance, security, resolving an error. For code review, I've heard, at least there was one study that said that it sped up code review by 50%. So basically pairs of people that might be required under previous regimes, now it only requires one person. And again, basically, if it's put into an AI tool, it can, if it's connected to a sort of a public data set that's used for the AI tool, it could be providing it directly to a competitor. And they're probably, again, facing the same problems code-wise that your company is.
All right, let's
So
move to the next slide.
Next slide.
Sure.
In the news, Mike, if you want to cover some recent things.
Yeah. So one of the biggest pieces of news in the last, I don't know, 6 months or year was the Samsung situation where sensitive internal source code was put into ChatGPT. And basically Samsung responded by banning the use of ChatGPT and other AI-powered chatbots because that was a severe problem for them. As Amazon issued a warning to staffers after it discovered example ChatGPT output that resembled internal Amazon data. So one thing to think about is, even if you've got a policy within your company to deal with AI risks like these, is you want to have also a way of monitoring to see if things are still leaking or getting put into AI things. And then similarly, major US banks restricted use due to concerns about potential regulatory risks surrounding and sharing of sensitive financial information. Now, of course, for any of the people concerned about privacy, which a lot of companies are nowadays, you definitely want to consider issues that are created with GDPR compliance, or even more seriously, potentially protected health information, or PHI, which might be relevant to your company.
All right, next slide.
Well, quick, Michael, is this something that, I know that the Amazon situation where I just wanted to maybe see if we get some more clarity on what they saw there. So it was somebody at Amazon, were they using ChatGPT for something else, and then all of a sudden stumbled upon what looked like internal Amazon data there, and then figured that someone had plugged it in, or what happened there?
I think I don't know if all the details were
Sure.
were released about how they found it. I think primarily because they didn't want other people to go searching for that.
Right.
But I think the most likely situation is sort of as you've described, where basically somebody else was using it and started to notice the data. I know there are tools that have been created to detect if ChatGPT has been used to output data. Of course, there's a concern in schools and stuff like that of kids using it for their homework. But
Right.
there was someone who made the news because they created a tool that used ChatGPT basically against itself, or at least in the way, or as a method of detecting if ChatGPT had output data.
Got it.
Yeah, I jumped the gun a little bit and asked some of these questions earlier on what you should do. But why don't you just talk about a path forward and talk about some of the things that you may not have covered earlier?
Sure. So I think one of the key things to note is that the stuff I've said before and the problems that are created are based on the fact that when you have a public data set that the AI platform is using and or updating, you can, that's where the sort of leak of public data can happen. So one of the ways to deal with this is sort of have an isolated model instance. So a lot of AI platforms provide a service which usually costs money, where basically you've got an isolated instance of the large language model, for example, in the case of the generative AI stuff, that will basically isolate your data. Think of sort of if your company uses the cloud, they usually have an isolated portion of the cloud for their own stuff so that they're not sharing data. So basically that's something you want to basically, if your company is going to use AI, make sure that they do. And you basically want to also keep users from using the business instances for personal queries, because that could modify the data, potentially modify the outputs, and other things, as well as sort of make your models not as focused on business related information. And then one of the key parts of that is to have the relevant agreements with relative protections. So one of the things that people have pointed out with regard to generative AI is about ownership. Now, of course, for the transactional attorneys here, feedback can often be an important part for software, for example, in a software agreement where basically a user of the software may provide feedback, suggestions, or other features or other comments basically about bugs or other issues related to performance. So that can, of course, be important for AI, but you definitely want to see what the ownership is. For example, a lot of AI platforms currently, the ownership is basically, as far as output goes, owned by the AI platform. And then, of course, common issues related to transactional or contracts or agreements is retention of data after the agreement ends. And is there a process for getting data removed? For example, if you had trade secret or other confidential information accidentally put in. Another concern I would say is the platform run by a competitor? Now, AWS or Amazon has been getting involved in AI, just like many of the big tech companies. But I've heard of cases where some brick and mortar retailers won't use AWS because of concerns about Amazon having access to their sales, product, and inventory data. Now, this was even before AI, but of course, that is something to consider. Then I'd say you definitely need some employee education. I mean, it's sort of the wild, wild west with AI these days, basically. So you probably want to have training done, potentially internally or with third-party vendors, and potentially have that redone frequently, because you not only want to catch new employees, but also make sure that you're reminding the current employees of the risks and dangers and the appropriate use of AI tools. You can potentially require the training before the use of AI tools. And there's also concern, you also want to deal with how you're going to deal with if somebody's putting something out in the public as far as outputs go that were generated with AI, if you're going to have some sort of disclaimer related to that. So I've got sort of some example input limits here then. So potentially no source code, no trade secrets. You probably want to have a culture established of ask people or ask the legal department before they do things with AI tools, no confidential information, or at least limited, especially even if you've got your own instance of an AI tool. If it was to be hacked or something like that, then potentially your confidential information could be exposed. And I would say consider a form for AI tool requests so that people can justify it, what it's going to be used for, and stuff like that.
Very helpful. Thank you very much, Mike. We appreciate it. Good tips and good summary. Are there any questions from the audience? Okay. If not, we are running a little short on time. So why don't we touch on the last topic, the patent inventorship, and then we can just save a few minutes and see if there's any questions at the end for the presentation. Okay.
So Justin, you want to, obviously this is a topic that is not necessarily new, but it's just you had run up against this recently, and we're trying to offer some reminders, right, of some of the things to watch out for here.
Yeah, I've seen lots of mistakes in the in-house community. So I just wanted to share a few things that are very helpful, just kind of as reminders. Patent inventorship, I'll do a quick summary of what it's all about. With patents, you must list the complete and correct group of inventors. If the designated inventor of an issued patent is inaccurate, like if you omit a person who is a true inventor and you don't add them, or if you include a person that is not a true inventor, this is the important part, is the entire patent is invalid and unenforceable. So that's a high penalty for not doing what you should be doing. So why don't we skip down to the tips, the last slide. And I can kind of add an insight here. So I've seen a lot of colleagues that go to a company and just add the company's owners that may or may not have, contributed on the actual claims. So that's a big no-no. You have to contribute on the claims. So just because you're an owner doesn't mean that you should put it on. One other thing that I've noticed is a team of engineers, hey, we work together as a team. We want to bring everybody together. So everybody needs to be added to the patent. And that's also a big no-no. You actually have to invent something that goes into the claims. So yeah, just do not do that. Kind of related to the last topic, as of now, don't add AI. You can't do that. It has to be a natural person, a human being. There was a recent Federal Circuit case. I believe this is the most recent one, the Thaler versus Vital, that says that AI cannot be listed as an inventor for purposes of obtaining a patent. I know they tried to get cert from the Supreme Court. They were not successful. The USPTO has published 2 notices in the Federal Register seeking comments. So it might be a good idea to add some comments. But yeah, just don't add the AI. And also what's important is to secure patent ownership rights through agreements, simple assignment languages. So when an employee signs up with the company, have them sign an employment agreement, they agree to assign all all patent rights to the company, and that will make you feel more free that you can add the proper inventors to these patents. Also, what's important is to look at your past, do an audit, look at your past patents, see if there's someone that was improperly listed, or see if you forgot to add someone and add them as inventors. Those are some in-house tips and reminders that I think would be helpful.
Justin, just on the one quick question on if a company does employ the use of AI, let's say in connection with their like an engineering unit, and the engineering unit develops something new, but AI contributes in some way, is there anything that they, that you would recommend that in-house folks do to watch it? I mean, obviously we don't list them as inventors now, but there's something to note, or is there a notation needs to be made in the company's files that occurred if something changes in the law, or what would you recommend?
Yeah, I would definitely make a note in the file for the future. So if there is some sort of change, that they can later be corrected. But I would also check what they contributed. Make sure that what they did contribute doesn't infringe any other patents or anything else there, where they may have gotten the source from. Make sure that source is valid, and just be very, very cautionary with using AI to help. It may be good to use it as a guide, but at the end of the day, double check, double check, double check.
Okay. I think that kind of covers our presentation today. Is there any, we have 5 more minutes. If anybody has any follow-on questions, we're happy to, happy to answer those. I don't see, let's see here. There's one question. Can you see that in the chat, Justin?
Unfortunately, I can't.
So Xavier, looks like Simeon. I may be mispronouncing your last name, but he had asked, is there a way to gain any further information and expand our knowledge on the first topic? Rob, in terms of third-party litigation funding, is there any sources of materials that you'd recommend for further study on that topic?
Yeah, so last year, the Government Accountability Office released a report with an overview on third-party litigation funding. So that's a good source. There's also an organization, it's cited in my slides. They also did a report this year using 2022 data on third-party litigation funding. They identify, for example, some of the well-known third-party litigation funders and provide some survey data from them. I think those are the two best sources.
Okay. And oh, we got another question here. We got a couple. Do you envision scenarios in which NPEs succeed? Bill Graham, I'm not exactly sure. Do you envision scenarios where NPEs succeed? Michael, do you have any, the question is, do you envision scenarios in which NPE succeed? Do you have any feedback on that question?
Well, I mean, I'd say as far as there's of course cases where they will succeed. I mean, basically it's I mean, NPEs can succeed basically if they've got a really good patent that really reads on your product and
Right.
or your company. So, I mean, it's one of those situations where even if they have a good patent, potentially fight it. But if they've got you, sort of, I mean, it's sort of like dealing with a bully. If they're going to be troublesome, if they've actually got good patents, then basically it may be necessary to put up a fight. I mean, one of the things I will say that's dangerous though is to realize that NPEs have their own conferences, and with those conferences, they tell each other who's paying up. So even if they bring you a good patent, if you basically sort of quickly sell it or something like that, you may get yourself into trouble where you basically have a reputation of basically paying up early, which is something you definitely want to avoid. So it's sort of like a reputation thing. But yeah, I mean, there can definitely be cases. I mean, basically, I mean, for example, that VLSI case, is my understanding, is basically, VLSI is not the company it used to be. It's not really much of an operating company anymore, is my understanding. And so, and in fact, that the patent that VLSI is suing on actually came from another semiconductor company, is my understanding based on what I've heard. So I think there are cases where they can succeed. You may remember some of you may remember the BlackBerry cases from way back in the day, where there was basically an NPE, and that got all the way up to the point where Congress was actually getting involved because they were all using their BlackBerries. Now, of course, that's dated, but yeah, there are cases where the NPEs will win. And you've really got to evaluate things when you get a letter or a case filing from an NPE to figure out how close it is. I mean, basically, it's probably better to settle things depending on how good the patent is and what kind of fight or willingness they're going to put in. I mean, one thing to remember is I touched upon is their NPEs are companies. So the more time and money that you can use up of theirs is something that they are concerned about, because if it's taking them forever to get something, you're sort of limiting their ROI over time. So I'd say that's something to definitely consider, but really it's sort of a fact specific or situation specific situation.
Sure. And then I think we have last question. I think we got to run. Brad Groff asked if you use AI in developing an invention, and we kind of touched on that earlier. Is there any duty to disclose that on an IDS? Has anybody seen a situation in which that's something that we should be looking out for?
It hasn't come up for me yet, so I don't know the answer to that question.
Yeah, I haven't heard of that either. But I think it's a very good question. I think it's going to, of course, be sort of a thing. Although, I guess to some degree there may be an argument to be had that basically the AI is more of a inventor potentially, or at least, I mean, not an inventor under current rules, but then required as an IDS. Although I don't know if you'd want to have to submit your outputs from AI as part of an IDS, because that could be something very useful for a competitor to look at, because they can see what you're querying, what your output is, and other things. So I think there's a lot of potential risks along that, but at some point we may have a decision or a rule for that.
Yeah, I suspect the law is behind what's going on in the marketplace, so I'm sure we'll catch up at some point soon.
Joe, do you want to move to the last slide real quick?
Yeah.
And then one thing I was going to add here, if anyone has any questions, our email addresses are attached here too. Feel free to reach out to me with any follow-up questions from the presentation. I'm sure everyone else is available as well.
Yeah, I think we're going to work with, several of you asked me for the slides today. I think we'll, either I'll get them to you if you email me directly, or I'll work with Lane to make this available. I think this whole presentation will be made available on the section website shortly with the slides, but we'll make sure those are available. All right, well, I appreciate everybody's time today, especially from the panel. I know they worked really hard to put this together for everyone today, so I appreciate your efforts, and thanks for all those joining and tuning in today. I appreciate it. Everybody have a great day.
Thank you very much. Have a great day, everyone.
Thank you, everyone. Have a great day.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.